Trial resumed. Jury not present.
The court said, "Good morning. Please make your appearances."
Mr. Ferguson said, Micah Ferguson, Ryan Finkel, Julie Murray, and Justin Horton for the United States.
Ms. Schrofa said, "Good morning, Your Honor. On behalf of Mr. Gua, Sabrina Schroff. Mr. Gua is standing to my left."
The court said, "Please be seated. Is there anything that either side would like to bring up?"
Mr. Finkel said, "Your Honor, first one minor scheduling issue. The witness, in consultation with the defense last night. We're reordering the witnesses. The witness who is going to go on after the current witness has an immovable appointment at 11:45. We think he's a very short witness. To the extent that he's a United States Attorney Office paralegal. So he's accessible. To the extent we can't get him finished with cross at 11:45. We'd ask that he sort of stop and we call the next witness, and then we can bring him back either later today or tomorrow when he returns. I hope that's not an issue for the court."
The court said, "No problem."
Mr. Finkel said, "There's a second issue, and I was wondering if we could discuss that one at sidebar."
The court said, "Okay, we're going to go into the robing room because they're going to have to deal with the AV over here."
Pages 4069 to 4072 sealed. Continued on next page. In the robing room.
The court said, "Anything else?"
Ms. Schrofa said, "As I was walking to court this morning as I normally do past the passageway, I was on a phone call with a pretrial services officer on an unrelated matter. I heard somebody say hello. I turned around. It was a juror. The juror immediately recognized that they shouldn't have said hello. They looked embarrassed. I didn't respond, and everybody went on their own merry way. I literally was on a phone call. I just wanted to let the court know."
Mr. Finkel said, "Which juror?"
Ms. Schrofa said, "There were two of them together. One was a man. One was a woman, but it was literally moments. When I look at them, I could tell you. I was just walking to court. I think they were behind me. I can't remember."
The court said, "So would it suffice for me to just remind the jurors that they'll not to have contact with the lawyers?"
Ms. Schrofa said, "Your Honor, it would look like I sort of ratted them out. It was so inconsequential that I really thought I shouldn't mention it, but I did so as an abundance of caution." Literally, the juror looked abashed that they'd done that. They made a gesture, like, "Why did I do that?" The two were talking to each other. It was the tall man, the female. I think she's in the second row or maybe the first row. It was so inconsequential, literally nothing.
Mr. Finkel said, "The government has no issue with proceeding however the court sees fit. This seems like no issue. I would just ask that Ms. Schroff inform the government which juror numbers it is just so we're aware. Other than that, I don't think there's anything that unnecessarily needs to be done. Of course, the government has no objection to Your Honor reminding the jury of their obligations and requirements as jurors."
The court said, "If Ms. Schroff is asking that I not do that, then I won't do it."
Ms. Schrofa said, "It really was nothing. It was so inconsequential. I even thought I shouldn't bring it up. But just to be careful."
The court said, "Okay."
Mr. Finkel said, "Your Honor, given the nature of what was discussed in the first part of this conference in the robing room regarding the victim, the government would request that that portion of this conference be sealed."
The court said, "Yes. All righty. Thank you."
Continued on next page. In open court.
The court said, "Please have the jurors brought in."
The law clerk said, "Jury entering."
Jury present.
The court said, "Please be seated. Good morning, jurors. I brought you in at 9:34 because we had an audio/visual failure, and so I needed to have that fixed first. Remember yesterday I asked whether you would be able to stay until 5 o'clock on July 2nd and 3rd. Is there anybody who cannot do that? Very good. I appreciate your cooperating with me in this way. We're going to now continue with the direct examination of the witness. Sir, remember that you are still under oath."
The witness said, "Yes, Your Honor." Douglas Skalka resumed. Direct examination continued. By Mr. Ferguson.
Good morning, Mr. Skalka.
Good morning.
Yesterday you explained at a high level the process for your fees being paid. Do you recall that?
Yes, I do.
Do you know even just a ballpark estimate of approximately how much in fees your firm has been paid for the bankruptcy work?
Approximately $2 million.
And do you have, again, ballpark number of how much Paul Hastings has been paid for its bankruptcy work?
Approximately $25 million.
And can you remind us how much in assets have been recovered to the bankruptcy estate?
Over $100 million.
Ms. Loftus, if we could go to 1404B. If we could scroll down, Ms. Loftus. Mr. Skalka. Do you remember looking at this transcript when we broke yesterday?
Yes.
And what was the date of this meeting of creditors?
April 6, 2020.
How soon after the bankruptcy proceedings were filed, just for context?
A month and a half after the filing.
So, Ms. Loftus, maybe we can blow up the bottom half or so and we'll just scroll through. Now I'll read the questions, Mr. Skalka, and you can read Mr. Kwok's answers. It says, does Greenwich Land, LLC yes? Greenwich Land, LLC, own any real estate other than 373 Taconic Road?
I don't know.
Do you know anything about the property located at 3333 Ferncliff in Coscob, Connecticut? If we can just scroll down. Then you can read at line 2, Mr. Skalka.
Yes. Now I remember it. It's also owned by my wife's company.
That being Greenwich Land?
Maybe.
Do you know?
I'm not sure.
Have you ever been to 33 Ferncliff?
Yes.
How recently?
No, not recently.
Do you know when Greenwich Land purchased 33 Ferncliff?
I don't remember.
Do you know approximately how much money it cost?
Probably more than $1 million.
Does 1.37 million sound about right?
I'm not sure.
Does the approximate purchase date of September 2019 sound about right to you?
Not sure.
Turning back to 373 Taconic for a moment, how much was that property purchased for?
Probably $400,000 to $500,000.
And then it says the private interpreter, no, and then the official interpreter. 4 to 5 million. I'm sorry. The next question, approximate time of purchase of 373 Taconic if you know?
I don't know.
Have you ever resided at 33 Ferncliff?
No.
Do you know whether anyone currently lives there?
Before there is another comrade maybe, for disjoined Chinese Communist Party. And he was to live there.
How long ago?
Probably 1 to 2 years ago.
Do you remember that person's name?
Yes.
What is it?
Wang Dingan.
Does anyone currently live there if you know?
I don't know.
Talking about 373 Taconic, where did the money come from to purchase that property?
I don't know.
Do you know whether the house was purchased with cash or financing?
I don't know.
Same questions for 33 Ferncliff. Do you know where the money came from to purchase that house?
I heard it was purchased by cash.
From whom did you hear that?
I don't remember.
Do you know where that money came from?
I don't know.
If we could scroll down, Ms. Loftus. Do you know what Skalka Media Group is?
Skalka.
Skalka.
Skalka Media Group, I do.
What is Skalka Media Group?
Just Skalka, it's a company.
What kind of company?
I'm not sure.
Have you ever had any relations with Skalka personally?
No.
Do you know anything about the type of business that Skalka conducts?
I remember they are related to GTV Media Platform or they invested on the GTV Media Platform.
How do you know that?
Because I was their consultant who owned the consultant and also I was the GTV host. And also this is one of the input and platform for disjoined Communist Party.
When you said you were a consultant a moment ago, was that for Skalka or GTV?
GTV.
Has Skalka ever had the 162 East 64th Street address associated with it? And then the question gets repeated, and you can start at line 19.
I don't know.
That is the family office address, correct?
It's one of them.
Where are the other ones?
I don't know.
Are there others in New York City?
I just want to clarify, Golden Spring is one of the companies in this building 162.
Understood, and thank you. We referred to the family office during your questioning, and I just want to be clear. When we talk about the family office, are we referring to that address on East 64th Street?
Yes.
Has GTV ever been associated with the family office address?
I don't know.
Who owns Skalka?
My son.
Since when?
I don't know.
Does Skalka currently exist?
I don't know.
Do you have any idea how many? Do you know anything about the value of Skalka's assets?
I don't know.
Do you know anything about payments Skalka has made to GTV?
No, I don't know.
Has your wife ever told you about any multi-million-dollar payments from Skalka to Greenwich Land?
I don't know.
You don't know whether he's ever told you, or you don't know about the payments?
She never told me, and I don't even know how much.
Do you know a company called Ziba Limited, ZIBA?
I don't know.
I'm sorry if I've already asked this. What is the relationship, if any, between Skalka and GTV?
Skalka is the investor for GTV.
Do you know how much money Skalka invested in GTV?
I don't know.
When was GTV founded?
2020, maybe 2019, not very sure.
Do you know the names of any of the officers or directors of Skalka?
I don't know.
Do you know whether Yvette Wang is an officer or director of Skalka?
I don't know.
Do you know someone called Hong Chong Won?
Yes.
Who is that?
He's my partner and also comrade for disjoined Communist Party.
Is he a friend of yours?
Friend, comrade, and a partner.
What do you mean by partner?
Because we had a business corporation.
Tell me about that.
Well, I don't remember the name of that company. It's a company for investigating Communist Party in USA doing money laundering and committing crimes.
Was it a for-profit company?
I don't know.
You don't know?
I don't know.
What was the name of the company?
I don't remember when getting to English. I don't remember the name.
Approximately what time frame were you partners with Hong Chong Wang in this company?
I don't remember.
Within the last 3 years?
It must be more than 3 years ago.
More than 10 years?
No.
Did Hong Chong Wang ever have any connection to Skalka?
I don't know.
Was he ever an officer or director of Skalka?
I don't know.
What does the G in GTV stand for?
God, the goal, like in GOAL.
The English word goal?
Yeah, goal or God.
How long have you known Hong Chong Wang?
I don't remember.
More than 10 years?
Roughly.
And you still consider him a friend today?
Yes.
Just a moment, please. There's been many questions today about Golden Spring funding your living expenses. Is it correct that as far as your living expenses are concerned that none of that is expected to be repaid?
Yes, true.
And so those monies are not the subject of any formal agreement, correct?
No.
And those monies essentially then are a gift to you, correct?
Yes.
What's the rule of law foundation?
What does that mean?
The question is, what is it? And then the interpreter asks, rule of law foundation, yes, sir. And we can scroll down slightly. I'll hopefully save some time by just asking this question instead. Are you familiar with the rule of law foundation?
Yes.
Were you involved in its establishment?
Yes.
Did you contribute any money to it when it was formed?
Not myself.
Did you direct any entity to contribute to the rule of law foundation?
Suggestion in a direct and suggesting any difference.
If there was a suggestion, please tell me it was a suggestion?
I didn't direct anybody or order anybody. I just always suggest people to make donations for the foundation.
And then the private interpreter says, as an interpreter. I think if the witness is asking the interpreter questions, the interpreter should interpret the question asked by the witness instead of answer that question. The interpreter responds. We can scroll down. We can keep scrolling down. Again it says by Mr. Harbach. I'll start reading the next question. Did you ever suggest to any of your family members that they donate to the Rule of Law Foundation?
Yes, I did suggest.
Did any of your family members or the family-controlled enterprises contribute money to the Rule of Law Foundation?
Yes.
How much money?
For cash there is over $1 million from Hong Kong, Japan, and mainland in China. And all combined it should be more than 30 million.
Just focusing for the moment on contributions from your family at your suggestion. Approximately how much money is that?
I don't know the details, because of security reasons, they don't want me to know.
Did you say a moment ago that your family contributed over $1 million?
1 million cash is in New York here.
When was that?
I don't remember.
Is the reason well, let me ask it this way. Did you suggest an amount to your family members that they should contribute to the Rule of Law Foundation?
I want them to donate, the more the better.
Is that what you told them?
Yes.
Did you know whether the Rule of Law? Do you know whether the Rule of Law Foundation is associated with a family office address on 64th Street?
Yes.
Did you ever make a $100 million donation to the Rule of Law Foundation in November of 2018? Interpreter asked to repeat the question. It gets repeated, and you can answer the answer.
No. In the live stream, like I want, try to collect the funds in the live stream show.
You could see the private interpreter says. Not quite exactly what the witness said, indiscernible, broadcasting is okay. Live stream is okay. But collect money and the official interpreter says, asking for donation, right. Private interpreter says, raise. And then the witness testimony continues. You can start at line 17.
Raising money, raise donations. Yeah, in the live stream broadcast thing, or whatever, you know. Asking for donations to, you know, to raise funds, to raise money.
We can scroll down. Did you ever promise to donate $1 billion to the Rule of Law Fund? And then the interpreter asked 10 billion you said. And Mr. Harbach says, no, sir, 1 billion. And the answer is at 3.
I don't remember. I don't remember.
Do you mean that it's possible that you made that promise?
So we could reach that goal if we combine the organizations all over the world.
Understand. And it's a simple question. I just don't know the answer. Did you yourself ever promise to donate $1 billion to the Rule of Law Fund?
In the past 5 years, I did the live stream over 5,000 times. Some of the live stream could have reached 4 or 5 hours. It's hard for me to remember every sentence I said.
Well, I understand that, but I'm only asking about one issue. And it is whether you ever promised publicly or privately or anyhow to donate $1 billion to the Rule of Law Fund. And then correction said donate, and the answer to that question 24.
I don't remember.
I'll ask this one more time. Are you saying that it is possible that you made such a promise? You just can't be sure?
In front of Ms. Holly, I wouldn't say anything is possible, but this is a very serious issue. Now they start the scheme again.
Well, this isn't what did you have for breakfast 3 days ago. This is... Did you promise to donate $1 billion? And if the answer is you don't know, that's okay. Scroll down. And Mr. Baldiger responds. Who is he, Mr. Skalka?
He was Mr. Kwok's bankruptcy counsel at the time.
If we could scroll down a little more. I'll read the question, line 17. So the answer might be no. But you're not saying no? You're saying you don't remember?
I said it 3 times. I don't remember.
And you can continue at 21.
Because in the past 5 years, indiscernible, always making these kind of answers for me. So that's why the judge from the South District were fooled by you and you started again.
I'll move on. You can continue.
In the South District Court I only met Judge 20 seconds. I didn't say one sentence within this 5 years, and I was fined a total about $300 million because that's what they did.
And then just pause for a second, Mr. Skalka. The about $300 million. Is that about the amount in the PAX case?
The total judgment including the initial judgment plus the fine was approximately a little over $250 million.
And was that case in the Southern District of New York or in a state court?
It was in the New York Supreme Court, which is a state court.
If we can just scroll down slightly more. There's back and forth between the attorneys. Then the question continues. Have you made any donations to the Rule of Law Foundation in the last 2 years?
Myself, right?
Yes, sir.
No.
Have you suggested to any of your family that they make donations to the Rule of Law Foundation within the last 2 years?
I don't remember.
Would you ever have made a promise to donate $1 billion to the Rule of Law Foundation if you did not actually have that money? And ask to be repeated. Would you have ever made a promise to donate $1 billion to the Rule of Law Foundation if you did not actually have that money? And then, Mr. Skalka, you see line 11, it says the official interpreter, and you can read the line that starts, he said.
He said, are you want to sentencing me to death sentence?
Mr. Skalka, are there any death sentences in bankruptcy proceedings?
Not that I'm aware of.
And if we scroll down, Ms. Loftus. That's the end of the exhibit. We can leave it there. You can take that down, Ms. Loftus. Now, Mr. Skalka, after the meeting of creditors we were just looking at. Did there come a time when a bankruptcy trustee was appointed in Mr. Kwok's case?
Yes.
Approximately when was he appointed?
He was appointed by order of the Bankruptcy Court in June of 2022.
Ms. Loftus, could we please publish Government Exhibit 6-194? Ms. Loftus, if we could zoom on the top left. Please. Mr. Skalka, do you recognize who's shown in the top left here?
I recognize the person in the picture.
Who is that?
That's the Chapter 11 trustee.
Mr. Skalka, were you the subject of any protest?
I was not.
Who was?
Mr. Kumraju said, object to form.
The court said, sustained.
Who was the subject of the protest?
Mr. Kumraju said, object to form. It's the same question.
The court said, if you would lay the foundation, please.
Were there any protests related to the bankruptcy of Mr. Kwok?
Yes.
Who was the subject of those protests?
The Chapter 11 trustee was the subject of some of the protests.
Who else, if anyone, was the subject of the protest?
Paul Hastings' law firm was the subject of protest. PAX was a subject of protest. And the law firm representing PAX was a subject of protest.
Were any family members?
Yes, the daughter of the Chapter 11 trustee.
Mr. Skalka, in your 35 years of bankruptcy-related practice, how common are such protests?
Mr. Kumraju said, objection to relevance.
The court said, you may answer.
This is the first case I've seen these types of protest.
We can take it down, Ms. Loftus. Mr. Skalka, are Mr. Kwok's bankruptcy proceeding ongoing?
Yes.
Has PAX been repaid based upon Kwok's personal guarantee?
No.
Have any creditors been repaid yet?
None of the pre-bankruptcy often referred to as pre-petition creditors have been paid. Ongoing expenses during the bankruptcy case are being paid.
Mr. Ferguson said, may I have a moment, Your Honor?
The court said, go ahead.
Mr. Skalka, you mentioned PAX's law firm. What law firm is that?
O'Melveny and Myers.
Mr. Ferguson said, no further questions.
The court said, cross-examination.
Mr. Kumraju said, thank you, Your Honor.
Cross-examination. By Mr. Kumraju.
Good morning. Could you tell me again the bankruptcy trustee's name?
Luke Despens.
Now, Mr. Ferguson asked you over your last 35 years of bankruptcy, have you ever seen protest?
I believe the question was in bankruptcy cases. That's correct.
How common are Chapter 11 bankruptcy filings for individuals?
They're not as common as they are corporate entities. But I've been involved in several of them over the years.
Of the several of them that you've been involved in over the years, have any of those people been the subject of plots by the Chinese Communist Party to return them to China?
No.
Have any of them been the subject of a plot to kidnap that person and return them to China?
No.
Have any of them been the subject of a plot to discredit them online? Let me rephrase that. Discredit them online specifically by the Chinese Communist Party?
No.
Are you aware that Mr. Guo, all of those things happened to him?
I'm not.
So that's in prepared for your testimony today. Mr. Ferguson did not discuss that with you, correct?
No.
And could we have back up the photo from the protest? I think it's GXV 194 maybe. You remember you were asked some questions about this by Mr. Ferguson?
Yes.
Do you have any familiarity with what the phrase CCP running dog means?
No.
And do you see on that poster, do you see where it says take down the CCP?
Yes.
Do you understand this to associate Mr. Despens with the CCP?
I'm not sure what this is trying to be communicated by that poster other than, I just don't know.
Let's screen out, let's zoom out real quick. Now, do you see the bottom there's a number $250 million?
Yes.
And you see above it says extortionist appointed by the DOJ?
Yes.
Does that figure $250 million have any significance in the context of the PAX settlement negotiations?
I don't know. I have not been a party to the settlement negotiation between PAX and Mr. Kwok.
Mr. Despens has though, right?
Mr. Despens is the trustee representing the estate, which includes many creditors, not just PAX.
You're aware that there were negotiations between PAX and Mr. Guo's counsel to settle PAX's claims. Correct?
Mr. Ferguson said, asked and answered.
The court said, sustained.
Were there any negotiations between Mr. Despens and Mr. Guo's counsel to settle the bankruptcy?
There was a court-ordered mediation in the bankruptcy. And so there were negotiations as part of that bankruptcy court-ordered mediation.
Did Mr. Despens make a demand as part of that court-ordered mediation?
I was not present during the mediation, so I believe he did. But I was not present for those mediation sessions.
To your understanding, what was that demand?
I don't know.
The court said, Mr. Kumraju, please speak into the microphone.
Mr. Kumraju said, sorry, Your Honor. Now, you see it says appointed by DOJ. I think on direct you testified about someone named Ms. Claiborne.
Yes.
Who is she again?
Ms. Claiborne is a trial attorney for the Office of the United States Trustee.
And the Office of the United States Trustee, is that in any particular department?
My understanding it's a branch of the Department of Justice.
And the Office of the Trustee makes recommendations as to Chapter 11 trustees to the bankruptcy court. Right?
Yes.
That's what happened in this case, right?
Yes.
So someone from Mr. Claiborne's office recommended Mr. Despens, right?
Yes.
Was Mr. Despens the first trustee put forward to your knowledge?
He was not.
Who was the first one?
I don't recall the individual's name.
Do you have an understanding as to why there was a second trustee put forward?
My understanding is the first trustee had a conflict or conflicts.
And as part of Mr. Despens' selection, let me withdraw. As a general matter, is there any kind of vetting done of a potential Chapter 11 trustee?
It is my understanding that there is some vetting done, yes.
What's your understanding of what that vetting is?
There's an interview process. U.S. Trustee Office contacts people that they believe might be a qualified candidate to be a trustee. And at some point once they get down to a few candidates, My understanding is that there is some conflicts review being done by each candidate before they're selected.
And is it your understanding that that process happened in Mr. Gua's bankruptcy?
Yes.
Now, you remember Mr. Ferguson asked you about are there any death sentences in bankruptcy cases? You remember that?
Yes.
Do you know if there are any death sentences possible under Chinese criminal law?
Mr. Ferguson said, objection.
I do not know.
Now, you were also asked some questions about the PX litigation on direct, right?
Yes.
Now, PX filed its complaint against Mr. Gua on April 18, 2017, correct?
It was filed in early 2017. I don't recall the exact date.
I'm going to see if I can help you out with that. Can we put up just for the witness and the parties DX 7006? Please. Just please review it for yourself.
I see it.
So the question solely is: does looking at this document refresh your recollection as to the date of the filing of the PX complaint?
Yes.
Was that date April 18, 2017?
Yes.
You're aware that that's the day before the Chinese government filed an Interpol red notice against Mr. Gua. Right?
I'm not aware of that.
You're aware that that's the day before Mr. Gua did a live interview about Chinese corruption for Voice of America. Right?
I'm not aware of that.
What is PX exactly?
It's an entity that lends money or lent money in this circumstance to a business known as Shiny Times Holdings.
Do you know any significance to the fact that it's named the Pacific Asia Alliance Opportunity Fund?
I do not.
Do you know where it's based?
I do not.
Do you know if it has a focus on investments in Asia?
I do not.
You didn't represent any of the parties in the PX litigation, right?
I did not.
So your familiarity with that case comes purely from reading documents filed in it, right?
And hearing about the case in bankruptcy proceedings, but yes.
All second-hand information, right?
Correct.
You didn't attend any of the hearings in the PX litigation, right?
I did not.
You didn't intervene in any way in the PX litigation, correct?
Correct.
And when Mr. Ferguson was asking you questions about the PX litigation, he went over with you the documents that he would like you to read from, correct?
Yes.
And he went over with you the questions that he was likely to ask you, right?
Not specifically.
Well, I'm not saying he asked you the specific questions. Generally speaking, he told you what he'd like you to talk about, right?
Correct.
Mr. Ferguson asked you some questions about a state court order in the PX litigation. Do you remember that?
He asked me about several state court orders, I believe.
Let me be specific. I meant the one granting summary judgment. Do you remember that?
Yes.
When the summary judgment order was granted, that meant that there was effectively obligation for Mr. Gua to pay some money, right?
Yes.
And that was north of $100 million, right?
Yes.
And I think you testified that PAX was seeking to collect on that judgment, right?
Once that judgment was entered, yes.
After the judgment was entered, PAX was making efforts to collect, right?
Yes.
And Mr. Guo wasn't paying it, right?
Correct.
Now, from your experience in the bankruptcy case, you're aware that Mr. Guo claimed in that case that PAX is controlled by the CCP, right?
Yes.
And, in fact, the protest that you refer to against PAX, Mr. Guo linked those also to the CCP, right?
I believe that was his claim.
And the same with the protest against the trustee, correct?
Yes.
Now, in addition to aligning PAX with the CCP, Mr. Guo also claimed that the trustee had scuttled a settlement between PAX and Mr. Guo's lawyers, correct?
Mr. Ferguson said, object to form.
The court said, sustained.
Are you aware that Mr. Guo claims in that motion included that the trustee had scuttled a settlement between PAX and Mr. Guo's counsel?
Mr. Ferguson said, object to hearsay.
The court said, I'm going to allow the question.
I'm sorry. I don't recall a particular motion that was filed by Mr. Kwok related to the negotiations or mediation. That was your question.
In any bankruptcy filing that you're aware of in Mr. Guo's bankruptcy proceeding. Are you aware of him making accusations that Mr. Despens had scuttled the settlement agreement between PX and Mr. Guo?
No.
Now, leading into, the protest against Mr. Despens began in November of 2022, correct?
It was fall of 2022. I don't recall the exact date or month, but it was in the fall of 2022.
Around that time you're aware that Mr. Guo made a motion to disqualify Mr. Despens in the bankruptcy case.
My recollection is that motion was prior to the protest.
Sure. It was not immediately coincidental, but it was before, right?
Yes.
And as part of that motion, Mr. Guo's lawyer accused the trustee of being part of the CCP?
Mr. Ferguson said, Your Honor, objection to hearsay. This is not admissible.
The court said, I'm going to allow the question.
Can you restate the question?
Mr. Kumraju said, could we have it read back, please?
Record was read.
I don't recall that accusation.
Let me see if I can help you with that. Let me put up just for the witness and the parties, can I have just one moment, Your Honor, DX 60658. Just for the witness and the parties. Can we just scroll through that document for the witness? We can take that down actually. Sorry. Let's move on. Let's go back to the PX case for a second, okay? Now. There was first an initial contempt order filed in the PX case, correct?
Yes.
That's a conditional contempt order of some sort.
I believe it was referred to as the initial contempt order.
Whatever the term, there was one first and then there was one later, correct?
Yes.
And the first one fined Mr. Guo $500,000 a day until the Lady May was returned to New York, correct?
Yes.
Now, Mr. Guo faced potential time if he didn't comply, correct?
The official contempt order made no reference to jail time or additional fines. My recollection is that contempt order provided 60 days for Mr. Guo. Mr. Kwok to return the Lady May to the jurisdiction before the fines would start being levied.
Continued on the next page. By Mr. Kumraju.
Okay. And the yacht didn't come back though, right?
It did not.
Okay. Do you know where the yacht was at that time?
Based on the pleadings, it was indicated the boat, or the yacht, was in Europe.
Okay. Do you know if Mr. Guo was in Europe at that time?
I do not.
Okay. Now there were court hearings in New York in the PX litigation, correct?
Yes.
You testified about an evidentiary hearing, right?
Yes.
Mr. Guo was at those hearings, right?
I believe so.
Okay. So he wasn't in Europe at those times, right?
The evidentiary hearing was in February of 2022. I believe he was in New York for that hearing.
Okay. Now the PAX had also obtained a summary judgment order by this time, correct?
By February of 2022, yes.
Sorry. I meant by the time of the first contempt order going out.
Yes.
Okay. Now Mr. Guo didn't use any money from G clubs to pay that underlying summary judgment order, right?
No money was used to pay that summary judgment.
Right. So not G clubs money, not GTV money, not Himalaya Exchange money, no money, right?
Correct.
It went unsatisfied, correct?
Yes.
And in early 2022, PX moved for the final contempt order, right?
Yes.
And the court granted that on November 9th, is that right?
I believe it was February 9, 2022.
Oh, I'm sorry. I misspoke. Thank you. February 9th, right?
Yes.
2022, and the total fees/fines that Mr. Guo had to pay were $134 million, correct?
Yes.
Mr. Kumraju said, could we pull up GX 1413 at 2, please? Does everybody have it on their screens? Okay. Let me just give that a second. Okay. Great. Thank you. All right. So paragraph 2 there says, directed to tender immediate payment to PAX, correct?
Yes.
And the amount is $134 million, right?
Yes.
And then on paragraph 4, it says, payment of the amount set forth in paragraph 2 above shall be made to PAX within 5 business days of the service of this order. With notice of entry, correct?
Yes.
Okay. So Mr. Gua's deadline to comply I think was February 16, 2022, correct?
I believe that's correct. I mean, 5 business days. I didn't pull out a calendar. But I believe there's probably a weekend day in there, and so that is probably accurate.
Right. Right. Well, let me put it this way. He filed his bankruptcy petition on February 15, 2022, right?
Yes.
And that was the day before he was going to have to pay this, right?
Yes.
And I think you testified about it. There's a weekend in there, right?
Yeah, I believe so.
Okay. So the bankruptcy judge, withdrawn. The state court judge ordered Mr. Gua to pay more than $100 million in basically a week, right?
Yes.
And Mr. Gua didn't use G Club's money to pay that either, right?
Correct.
He didn't use Himalaya Exchange money to pay that, right?
Correct.
He didn't use GTV money to pay that, right?
Correct.
He didn't use rule of law donations to pay that, right?
Correct.
And Mr. Gua did face potential jail time if he violated this contempt order, correct?
That's my understanding.
And despite that, he still did not use any of that money to pay this fine, correct?
Correct.
Now instead, Mr. Gua filed bankruptcy, right?
He did file bankruptcy, yes.
Now when one files bankruptcy, it's fair to say that you have to give up certain information about yourself, right?
Financial information, yes.
Right. You have to disclose assets and liabilities, right?
Correct.
You have to publicly disclose that you don't have sufficient assets to cover your liabilities, correct?
You have to disclose the extent of your assets and liabilities. Sometimes it might actually show you can pay off your bills but maybe not pay them off right away. So, but you need to disclose them.
Can you explain what you mean with that last answer?
You can disclose assets that appear to be more than your liabilities.
But they might not be liquid, so you can't pay right away, right?
Correct.
So the fact that somebody declares bankruptcy does not mean that they don't have access to significant assets. It just means they don't have access to liquid assets at that moment, right?
Mr. Ferguson said, object to form.
The court said, sustained.
Okay. Well. Can you explain what you just meant then by the difference between liquid and illiquid assets in the context of a bankruptcy filing?
You can disclose assets that, and values of assets that are in excess of the amount of your liabilities, but they may not all be liquid at the time that you disclose them. Meaning that they may not all be in cash, they may be in forms of assets, whether it's real estate or investments, that are not able to be.
The interpreter said, sorry. The interpreters are requesting that all parties slow down. Thank you.
The court said, please slow down.
Mr. Kumraju said, will do, Your Honor. Please go ahead.
You're not able to liquidate those assets for some period of time and therefore not able to pay your bills.
And in this case the period of time was a week, right?
The purpose of the bankruptcy is often to provide debtors time to pay your bills. So, but you need to disclose the full extent of your assets, whether they're liquid or not.
Right. So what I was saying is the amount, well, withdrawn. We'll move on. Now are you familiar with the term, personal bankruptcy?
Yes.
What, colloquially, is meant by personal bankruptcy?
That means a bankruptcy filing by an individual rather than a business entity or a corporate entity.
Mr. Kumraju said, okay. Let's pull up, if we can, please, GX 1419, which is in evidence, please. Let's publish it. Actually. Sorry. Before we do that, could we go to GX 1407, real quick? Can everybody see it? Okay. Great.
By Mr. Kumraju.
This is Mr. Gwa's petition to file bankruptcy, correct?
Yes.
All right. And just to tie it down, if we can go to page 7, that's his signature, correct, electronic?
Yes.
And it was executed on February 15, 2022, right?
Yes.
Mr. Kumraju said, okay. Now can we go to page, sorry. The page just shifted on me, but can we go to page 1 of the, well. Page 10 of 14 at the top there on the PDF. It's a form, official form 104. There we go. Thank you. Now could we just scroll down a little bit? Oh, we lost it. All right. Thanks. Can we scroll down a little bit?
By Mr. Kumraju.
Okay. You see number 2 there?
Yes.
Okay. That's Golden Spring, correct?
Yes.
And it says, what is the nature of the claim? Can you read that?
Yes. Oh.
Yeah, could you read what it says?
Litigation funding.
And how much is disclosed as the approximate amount of this?
Approximately $21 million.
So does this reflect that Golden Spring is identified as having a $21 million outstanding debt?
This is a list of the 20 largest creditors as filed by Mr. Kwok. And Golden Spring is listed as the second largest creditor with a claim of $21 million.
Mr. Kumraju said, and can we go to page 13? Okay. And you see number 16 there?
Yes.
Okay. Can you read the creditor's name?
Lamp Capital, LLC.
And what's the nature of that claim?
Litigation loan.
And what's the amount?
$1 million.
Mr. Kumraju said, okay. If we can go to 1419 now, please. All right. This is another filing, I'm sorry. Do you need a sec? Okay. This is another filing Mr. Gwa's counsel made in bankruptcy, right?
Yes.
And Global Notes and Statements is basically an explanation document of some sort?
In this case, yes.
Okay. Provides additional details, right?
Regarding the documents, some of which we just looked at. The bankruptcy schedules and statement of financial affairs.
Okay. So let's just start with page 4, please. And I think Mr. Ferguson asked you some questions about question 1b. Do you remember that?
Yes.
And if you look down. Mr. Kumraju said, we can go to number 2, please, Jorge. Thank you. Okay. And he asked you some questions about this paragraph, right?
Yes.
Now can you actually just read the first paragraph, please?
Yes. The debtor also has access to an apartment located at the Sherry Netherland Hotel. 781 Fifth Avenue, New York. New York 10022, the apartment. The cooperative shares in the apartment are held by Geneva Holdings LLC, the US SPV. The membership interests in the US SPV are held by Geneva Holdings Corporation, the BVI company. The debtor holds all of the equity of the BVI company. However, pursuant to a declaration of trust and agreement, dated as of February 17, 2015, the trust date, the debtor holds such equity in trust for Bravo Luck Limited, the apartment owner. The debtor's son owns the equity of the apartment owner. On or about the trust date, the apartment owner funded the US SPV with the purchase price for the apartment. These funds came from entities owned or controlled by the debtor's son and not from the debtor.
Okay. So do you understand all that to be a long way of saying that Mr. Gua's son owned the Ch.11 apartment?
That's my understanding of what is being asserted in this document.
Right. That's what's said here, right?
Yes.
Do you know what the purchase price was when it was purchased by Mr. Gua's son?
Approximately, the purchase price was approximately $60 million.
Okay. And I'm not going to ask you to read the next paragraph, but if you could just take a look at it. Do you see there's a reference there below to, in the face of multiple court disputes relating primarily to the beneficial ownership of the residence, then it goes on to say, as between Bravo Luck Limited and PAX.
I see that.
Okay. So PAX had also initiated litigation regarding the Ch.11 apartment, correct?
It was regarding, I believe, Geneva, the two Geneva entities, Geneva Holdings LLC and Geneva Corporation.
And that litigation was commenced in the British Virgin Islands, correct?
Yes, and also in the New York Supreme Court action.
Okay. So there were two, right?
Yes.
And British Virgin Islands is sometimes referred to as BVI, right?
Yes.
Okay. And BVI is a regular place of business, correct? A lot of businesses are in BVI, right?
A lot of businesses are incorporated in BVI, yes.
That's for various corporate benefits, right?
That's my understanding.
Mr. Kumraju said, okay. Let's go to the next page. All right. I'm not going to ask you to read all of it, but question 3, you see where it says. The debtor has use of automobiles, including luxury automobiles and motorcycles. Do you see that?
Yes.
Then it says. All costs and expenses associated with such vehicles are provided for directly by family and family-controlled enterprises, correct?
That's what it says.
The court said, "One moment, please."
Mr. Kumraju said, "Yes, Your Honor."
The court said, "You may continue."
Mr. Kumraju said, "Thank you, Your Honor." If we could go to page 6, please. All right. And you see question 17?
Yes.
And Mr. Ferguson asked you a few questions about that on direct as well, right?
Yes.
Now of the individual Chapter 11 cases that you've had during your career. How many of them have had restraining orders? How many of them involve debtors with restraining orders imposed by the High Court of Hong Kong?
None other than the Kwok bankruptcy proceeding.
Right. He's the only one, right?
Of the cases I've been involved in.
Sure. Mr. Kumraju said, and could we go to page 7? And paragraph I, do you see where it says, in September and October 2017? The Chinese government raided the offices of Shiny Times and seized all accounting corporate records and many personal financial records. You see that?
Yes.
So in all those individual Chapter 11 cases you've done, how many of them have had debtors who have had their offices raided by the Chinese government?
This was the only case.
Okay. Fair to say that Mr. Gua's bankruptcy case is pretty unique, in your experience?
Yes.
Okay. And one of the reasons it's unique is because Mr. Gua declared basically having no assets, right?
No. I've been involved in other cases in which debtors have disclosed little or no assets.
The court said, "Sir, if you'll speak into the microphone so everyone can hear you."
The witness said, I'm sorry.
I have been involved in other bankruptcy cases in which the debtor has disclosed little or no assets. But, so that by itself is not unusual or make it a unique case.
Okay. Fair enough. I was just curious if that was one factor. I'm sorry. We didn't hear your answer. Was that one factor?
Yes, it's one factor.
Mr. Kumraju said, okay. Could we go to page 11, please? All right. Do you see Schedule 1?
Yes.
Okay. You see the sentence there that says, The debtor does receive support funded by family and companies controlled by family for housing, household and living expenses, correct?
That's what it says.
Okay. The fact that Mr. Guo received support from family and companies controlled by family would not make him ineligible to file Chapter 11. Correct?
Correct.
And in fact, there is a mechanism by which an inappropriate Chapter 11 filing could be dismissed, right?
There's a mechanism where parties can seek to dismiss a bankruptcy case for virtually any reason. The parties can move to dismiss.
And a creditor can do that, right?
Yes.
And PAX was a creditor in this bankruptcy, right?
Correct.
So PAX could have moved to dismiss the bankruptcy if it had wanted.
PAX actually did move to dismiss at some point.
Okay. And what happened?
The judge denied this at the same time that a motion was made to appoint the trustee. And instead of dismissing the case, the court granted the motion to appoint the trustee.
Okay. So Mr. Despens was appointed in lieu of dismissing the bankruptcy, right?
Correct.
Are you familiar with the term, trust fund baby?
Mr. Ferguson said, objection to relevance.
The court said, sustained.
Okay. Are you familiar with other instances in which a debtor has been supported by their family primarily?
Yes.
So that's not unusual in a bankruptcy case, right?
I've seen it before. I've seen it in other cases.
Now you testified you weren't party to the settlement negotiations or the mediation conference, correct?
Correct.
So as part of that, as part of your work as local counsel, do you familiarize yourself with the proceedings that are going on in court?
Yes.
And you submit the applications that go with that, right?
Yes.
And you describe the work that you've done?
That my firm has done.
Correct. And I think you testified on direct that Mr. Despens and his firm had received approximately $25 million in fees, right?
That's correct.
And that there had been, withdrawn. And where did those fees get paid out of?
The recoveries that have occurred to date in the bankruptcy proceedings.
And that's a little over $100 million, correct?
Correct.
So Mr. Despens's fees have been approximately 25% of what's been recovered, correct?
Approximately.
Sure. I'm not asking for specifics but approximately, right? Now when you testified about that, was it called a 314 interview, correct?
341.
341, okay. Thank you. So a 341 interview is where the debtor has to sit and answer questions, correct?
Correct. That's the creditors' meeting. 341 is a section in the bankruptcy code. Sorry to get so technical, and that's what refers to the creditors' meeting.
Okay. So is that a meeting that's available to all of the creditors?
Yes. All creditors get notice of that meeting.
Okay. And so any of them can show up and ask questions if they want, right?
Correct.
And is it appropriate to say the DOJ trustee? What's the best way to describe Ms. Claiborne's position?
I refer to her as the trial attorneys for the office of the U.S. trustee. So often it's referred to as U.S. trustee.
Okay. So it's fair to say the U.S. trustee can ask questions at that as well, right?
U.S. trustee's office actually administers or runs the meeting, so yes.
Okay. And they can ask questions about any of the debtor's financial affairs, right?
Yes.
They can ask questions about transactions that the debtor has entered into, right?
To the extent they know of them, yes.
Sure. They ask questions about assets and liabilities, right?
Yes.
And the debtor has to answer those questions, right?
The debtor is obligated to cooperate in the bankruptcy proceeding and answer truthfully.
Okay. Now you looked at I think a couple of excerpts earlier from that. Do you remember that?
From the transcripts of the creditors' meetings.
Yes.
Yes.
And Mr. Ferguson sort of did a little role play with you, right?
Yes.
I'm not going to do as much, but I'm going to try and do just a little bit, okay? Mr. Kumraju said, could we pull out GX1401A, please, and put it up on everybody's screen? All right. And if we could go to page 51 of the transcript first. And you see line 11 there?
Yes.
Mr. Kumraju said, okay. Actually, I'm going to, yeah, line 11 is fine. So I'll read it and then we can skip all that other stuff and then you can go to the answer, okay?
Okay.
Okay. Mr. Kwok, who is Max Krasner? And then I think it picks up at 22. That's Mr. Baldiga's answer.
He has to double-check with you because I cannot read and cannot remember English names well. So just the name, you said Max. If it's the name Max only, I know Max. But if you add another name to it, I'm not sure. I don't know.
Do you know a Max with respect to Golden Spring?
Yes, I know.
And what is Max's role with Golden Spring?
I don't know.
Well, do you know Max?
I don't remember.
Do you know more than one person by the name of Max?
For me, English name is very complicated. Like I can't remember the last name of my lawyer. If you add something else to Max, I don't know.
Mr. Kwok, the name Max Krasner is listed as the person to whom the mail for Golden Spring is directed to. Do you know why that is? Interpreter, sorry. Do you know why that is?
I only remember there is a Max at Golden Spring. I only know this one thing.
And what is Max's job at Golden Spring?
I'm not sure what role. Indiscernible, know he is in charge of finance, but I'm not sure.
What does he do for Golden Spring with respect to finances?
I was not involved in the management so I don't know.
Mr. Kumraju said, okay. Can we keep going with page 54 real quick? Just scroll down to line 20. Right there is fine. Thank you. Mr. Kwok. Do you have access to a credit card or a debit card provided to you by or through Golden Spring?
No.
Okay. As part of his bankruptcy filings, are you aware of Mr. Gwt disclosing any credit card debt?
I don't believe he did.
Okay. Did he disclose having any credit cards?
I don't believe he did.
The only property he disclosed was having an iPhone, right?
He disclosed some clothing, he mentioned a family dog, and some checks that had not been cashed.
Right. The Pomeranian, right?
Yes.
Okay. Now how often have bankruptcy debtors had no credit cards?
Mr. Ferguson said, objection to relevance.
The court said, you may answer.
I've seen it many times in business bankruptcy proceedings.
Sure. How about individuals?
I'm sorry.
How about individuals?
I believe I've seen it before. But more common to see credit card debt in individual bankruptcy filings.
Okay. Now you were asked some questions about a loan document. Do you remember that?
Yes.
Mr. Kumraju said, all right. So can we just pull up what's been marked as Government Exhibit 1316, please? Do you remember testifying about this on direct?
Yes.
Now the only time you've seen this document is in the context of the bankruptcy case, correct?
Yes.
So you weren't there when it was signed, right?
No.
You're not a Himalaya International Financial Group employee, correct?
Correct.
You are not an employee of HK International Funds Investments, correct?
Correct.
You don't know Megwa personally, right?
I do not.
You don't recognize the signatures on the document, right, other than Ms. Gua?
Other than Ms. Gua. I've seen her signature on several documents.
Right. But you've never actually seen her sign those documents, right?
Correct.
So do you see at the top, and there's a sticker at the top, but at the top left it says, Case 22-05003. Do you see that?
Yes.
And you see it says Doc 84-1?
Yes.
Do you know why that's on there?
Yes.
Okay. Could you explain to us why it is?
I believe I testified on direct that there was an adversary proceeding that had been commenced by HK International Funds Investments, USA. Commonly referred to as HK USA. An adversary proceeding is a lawsuit within a bankruptcy proceeding. And this is the docket number for that lawsuit that had been commenced by HK USA, and this document. This exhibit in this proceeding was filed as an exhibit in that adversary proceeding. And that's the document number that was assigned to this document when it was filed in the adversary proceeding.
Okay. So this document is now a matter of public record, correct?
Yes, it was filed in the bankruptcy court adversary proceeding, which is a public filing.
Mr. Kumraju said, okay. Could we pull up GX 1314 quickly? You remember testifying about this document before, right?
Yes.
Okay. And it too has that same docket stamp at the top, right?
Yes.
So it was also publicly filed, right?
Yes.
Now, and you similarly were not there at the execution of this document, right?
Correct.
Mr. Kumraju said, all right. Could we turn to page 4 of the document, please? All right. And you see the section that says purpose? You see that?
Yes.
And you see 3.2 there?
Yes.
Okay. Could you read the first sentence, please?
The total facility amount will be used as security for the court in relation to the yacht.
Okay. So what's your understanding of what it means to say, security for the court in relation to the yacht?
My understanding from reading this document was it was intended as a secured loan on the on the yacht. And to be disclosed to the bankruptcy court.
Okay. And why would it need to be disclosed to the bankruptcy court?
Because at the time of this loan being made, there were proceedings pending in the bankruptcy court about what was going to happen to the Lady May and whether or not PAX would be allowed to go back to the state court and try to pursue a recovery of the Lady May.
The court said, "What do you understand the word facility to mean?"
The witness said, "Facility, I believe, was defined earlier in the document, Your Honor, as the loan that was going to be provided by Himalaya to the borrower."
Okay. Could you look at the next sentence, please?
The period the borrower retains the total facility amount in the escrow account will be the time period from the date of this agreement to when the yacht is returned to the USA.
Okay. So is it fair to say that this facility amount was intended to be like a bond for when the boat would come back?
Yes.
Okay. And it was going to be held in escrow, right?
Yes.
Okay. So this $37 million wasn't to buy the yacht, right?
No. It was a loan to HK USA, who was then going to put it up as a bond in connection with the negotiated settlement of the Lady May in the bankruptcy court.
Right. No one's getting a new yacht with this $37 million, right?
No.
Okay. And do you know what happened to that $37 million in the escrow account?
Yes.
What happened to it?
The bankruptcy court, in connection with the adversary proceeding that is referred to here, ultimately found that the $37 million, as well as the Lady May, were property of the bankruptcy estate. And the funds were recovered by the trustee and put into the bankruptcy estate.
Okay. So that $37 million is part of the $100 million that you testified about before?
Yes.
And so after the trustee took that action, the $37 million could not be returned to the lender in this matter, right?
Correct.
Now all of this whole arrangement, was disclosed to the state court, correct?
Not that I'm aware of.
Okay. It was disclosed to the bankruptcy court?
Yes.
And so no one hid this arrangement from the court, correct?
Not to the bankruptcy court.
Mr. Kumraju said, now can we go back to 1316, please, GX 1316. Make sure everybody has that. Okay. Do you remember this? This is the side letter.
Yes.
Okay. And you testified that a side letter is a sort of an amendment to an agreement, right?
In this case, yes.
Okay. And again, you weren't present for the signing of this, right?
Correct.
You have no personal knowledge of the circumstances of the execution, right?
Correct.
Okay. Now do you see 1.3a? It says, the loan in the loan agreement will no longer be deemed to be secured against the yacht. Correct?
That's what it says, yes.
Okay. So the effect of this is that the yacht is no longer security for the loan, right?
Yes.
And you see the date on this document, April 19, 2022. Sorry. If we blow it back out, you'll see it at the top there.
It refers to the loan agreement being dated April 19, 2022, but I believe the date of this document is April 29, 2022.
You're right. Thank you.
That's all right.
So at that time, April 29, 2022, there were a number of different demands to the yacht, correct?
Yes.
Pax had a demand to it, right?
They had a demand to it for purposes of collection of their judgment, yes.
Sure. And the state court had entered a restraining order on it, right?
Yes.
So they couldn't have transferred the yacht if they'd wanted to, right?
Mr. Ferguson said, object to form. Calls for speculation. I'm not sure what the question is.
The court said, "Are you asking for a legal conclusion?"
Mr. Kumraju said, no. I'm just asking for his understanding.
The court said, "I'll allow the question."
It would have been possible for HKUSA to transfer its title interest in the property. In the yacht at that time.
Okay. But it didn't do that, right?
It did not.
It just left it there, right?
Correct. And as I said, HKUSA started a lawsuit to actually claim that they were the owner of the property, of the boat.
Right. They availed themselves of the U.S. court system, correct?
Yes.
And all of the disclosures that come with that, right?
Yes.
So instead of doing the title thing, they filed a lawsuit.
I don't know if they were planning to do anything with the title.
Fair enough. Because, again, you're not part of the company, right?
Correct.
You never spoke to Megwa about it, right?
Correct.
You have no idea what her thinking is, right?
Correct.
Have you ever heard of William J.E.?
I've heard the name.
You heard the name in the context of the bankruptcy?
Yes.
Okay. In what context did his name come up?
Just that he had a relationship with Mr. Kwok.
Okay. But you've never spoken to him, right?
Correct.
You have no idea what his reasons are for entering into any loans, right?
Correct.
Same with ACA Capital, right? You have no personal knowledge of anything at ACA Capital.
I have no connection to ACA Capital.
Same with the Himalaya Exchange.
Correct. I have no connection to Himalaya Exchange.
And you remember Mr. Ferguson asked you questions about a draft loan agreement, right?
Yes.
And that draft had ACA on it, right?
Yes.
And then it switched to the Himalaya International Financial Group in the final, right?
Correct.
Have you ever heard of a typo?
Mr. Ferguson said, objection.
The court said, sustained.
Mr. Kumraju said, now if I could have just 1 minute, Your Honor. Now you're what's called local counsel, is that a fair description?
Yes, and conflicts counsel as well.
Okay. So Mr. Despens's firm hired you as local counsel, correct?
Hired my firm, yes.
Yeah, sorry, your firm. And you testified that your firm has made roughly $2 million based on that engagement?
Yes.
I'm not asking for particulars, but is that a big, small, or large engagement for your firm?
We're a 40-lawyer firm. I've been in practice with the firm for 30 years. We've had larger matters, we've had smaller matters, so I.
Okay. So it's not substantial, not insubstantial.
Correct.
And you testified before about a process by which the trustee, I'll call him the Chapter 11 trustee. Mr. Despens, right, how the Chapter 11 trustee was selected, not selected, recommended by the U.S. trustee, right?
Correct.
And that recommendation is a necessary step to somebody being appointed Chapter 11 trustee by the bankruptcy court. Right?
Yes.
So if a person wanted to be a Chapter 11 trustee in the District of Connecticut, they would need that recommendation, right?
It's actually an appointment by the office of the U.S. trustee, but yes.
Okay. Sorry. Let's use that word, to make it accurate. So to be appointed, they would need the approval of the U.S. trustee, right? And that's true for every bankruptcy case in the District of Connecticut that comes next, right?
As far as Chapter 11 trustees, yes.
So if Mr. Despens wants to plan to be a Chapter 11 trustee down the road, he needs approval from the U.S. trustee, right?
Yes.
And again, that's a department of the Department of Justice, correct?
It's my understanding it's a branch of the Department of Justice.
Now you were hired by Mr. Despens's firm, correct?
We were hired by Mr. Despens.
Okay. And that's his decision, right?
Correct.
He could always decide to hire somebody else down the road, right?
Yes.
He could change horses even in this case, right?
Absolutely.
Like you said, it's ongoing, right?
Absolutely.
So he has an opportunity to pick a different firm if he'd like to, right?
Yes.
Now you understand Mr. Despens has spoken with the prosecutors on a number of occasions, correct?
I don't know.
Do you know if he's ever spoken with them?
I don't know.
When were you approached about testifying in this case?
Approximately 2 weeks ago.
Do you know if prior to you being approached Mr. Despens was going to be a witness in this case?
I do not.
Now as part of Mr. Gua's bankruptcy proceedings, you and Mr. Despens had filed a number of court cases. I think you mentioned, right?
Yes.
I think you said it was over 300, right?
Yes.
And all of those are to recover assets back into the estate, correct?
Yes.
Okay. And by recover assets back into the estate, the trustee's allegation is that that money actually belongs to Mr. Gua, right?
They belong to the bankruptcy estate, and it's the Kwok bankruptcy estate. So the funds would be there to pay creditors of the estate.
Right. Ultimately, the funds would be used to pay the creditors, right?
Yes.
And they'd be used to pay his creditors.
Correct.
Right? And you're paying his creditors with his money, right?
With the funds that we believe belong to the bankruptcy estate.
Okay. And that's his estate.
Yes.
And the larger the estate, the more money there is that's available for your fees, right?
My fees would have to be approved before they would be paid. But if there's the large, I'm not being paid on a contingency fee basis, I'm being paid on an hourly basis. Southwest, the larger the estate doesn't necessarily mean I'm going to get paid more money.
No. My question was, there's money available to pay you, sir.
The court said, Mr. Kamraju, please speak into the microphone.
Mr. Kamraju said, sorry. My apologies, Your Honor. Did you hear my question?
Yes. The larger the estate, there's more money to pay my firm's fees.
Okay. And you testified that Mr. Despens is not taking a commission, right?
Correct.
But the same is true of him, right? The larger the estate, the more money that's available to pay his fees, right?
And all other expenses of the case, yes.
Sure. To pay all of it, right?
Yes.
So if his fees go north of that $25 million, it's got to come out of the estate, right?
Yes.
And many of the lawsuits that you filed have subject matter that overlaps with the allegations in this case. Correct?
I don't know.
Well.
Mr. Ferguson said, "Objection, Your Honor."
The court said, "You'll step up, please."
Continued on next page. At the sidebar.
The court said, "So why would that be irrelevant?"
Mr. Ferguson said, "We believe it is excluded under Rule 403. He's not charged with bankruptcy fraud, 1, 2. It goes well beyond the scope of the direct, 3. It is improper to try and impugn the criminal prosecution and the allegations we've brought by trying to impugn the bankruptcy trustee when there's already been significant cross on the fact that Mr. Kwok has said he's an agent of the CCP. You can't use the bankruptcy trustee's actions and their similarity to our allegations and overlap to try and make some kind of insinuation about our case and that this is improper. Excluded under 403.
Mr. Kumraju said, "I'm sorry. I wasn't sure if he was done. No. I'm merely asking it to set up a bias cross with respect to this particular."
The court said, "A what?"
Mr. Kumraju said, "A cross on bias, Your Honor, with respect to this particular witness. The line of questions are going to go, there's an overlap. You're aware that the government could ask to pause your case. In fact, you voluntarily paused your case. And you voluntarily paused your case so as not to interfere with the criminal case, including, in particular, to not have any of the government's witnesses deposed by Mr. Gua. And he did that, right? And they've said that in public filings. And so it's just bias, like you would cross anybody else. Like you would cross a cooperator, you took all these steps to help the government, that's all."
The court said, "What is the nature of the bias?"
Mr. Kumraju said, "The nature of the bias is that he and his firm get paid the longer the bankruptcy case goes on. And as long as they continue to work on it. If the government pauses it, right, if the government takes any action, then he doesn't get those fees. It's that simple. His fees are basically dependent on them."
Mr. Ferguson said, "Your Honor, Mr. Kumraju moved for the stay of the bankruptcy, not the government."
Mr. Kumraju said, "No, no. But he also moved for the stay of the bankruptcy case. That's my point. I'm not bringing out that we moved for the stay, I'm bringing out that he moved for a stay."
Mr. Ferguson said, "How is that bias?"
The court said, "He's somehow now interested?"
Mr. Kumraju said, "If they said in a public filing, I am voluntarily staying this incredibly lucrative case that we could be bringing because I don't want to interfere with the government's case and I don't want the government's witnesses to be deposed. That is a person or a firm or an entity offering to help the government in the same way that if I had 3,500 material that a cooperator said, 'Look, I'll go make a recording against the co-defendant,' I would be allowed to cross and be like, 'Look at all the efforts this person is willing to make.' It's not that dissimilar from the cross I was going to do on Mr. Bass, who I understand is now not going to be a witness. It's the same idea. It's just bias. It's the lengths to which they will go to help the government."
The court said, "Or themselves."
Mr. Kumraju said, "Could be both." Yeah.
The court said, "Okay. Go ahead."
Mr. Ferguson said, "If he's going to bring up the stay, then I think we can ask on redirect about how Mr. Kwok moved to stay the bankruptcy."
The court said, "All right. I'm going to permit the question."
Mr. Kumraju said, "Okay. Thank you, Your Honor."
Continued on next page. In open court.
The court said, "You may continue."
Mr. Kumraju said, "Thank you, Your Honor."
The court said, "Do you want the question to be read back?"
Mr. Kumraju said, "Yes, that would be great."
The witness said, "Yes."
The court said, "Go ahead."
Record read. By Mr. Kumraju.
One of the actions that the trustee filed is against G clubs, correct?
I believe so.
And one of the actions the trustees filed is against ACA, correct?
I believe so.
One of the actions it filed is against Golden State, New York, correct? Golden Spring, New York. My apologies.
Golden Spring, yes.
Same with GTV, correct?
I don't recall whether GTV was named in an action.
Okay. Have you ever reviewed the indictment in this case?
I don't recall if I read the entire indictment.
Okay. Have you read some of it?
I believe I read some of it.
Okay. Do you remember that G clubs is part of the indictment in this case?
I do not.
Now are you aware that the government could seek to pause the bankruptcy case?
No.
Okay. The government could seek to file a motion to ask the bankruptcy case to be stayed, right?
I believe any party could theoretically file that motion.
Sure. So them too, right?
If you're referring to the government, yes.
Yes. Right? And if that were successful, that would mean that during the period of the pause, there would be no more fees for you, right?
If you're referring to my firm.
Yes, sir. I'm sorry. Your firm.
I don't know what the bankruptcy court would do during a pause of the case. There's still administrative things that would take place even if the bankruptcy case was paused.
The court said, "Please speak into the microphone."
The witness said, "I'm sorry."
There would still be administrative proceedings that would take place even if the case was paused, from the sense that no litigation would be going on. There are still obligations. Monthly obligations of documents that have to be filed in the case just to keep it going and alive, frankly, so.
So it's fair to say that your fees would be less.
There would be less work, yes.
Right. And the same is true of Mr. Despens's firm, correct?
Yes.
Now are you aware that Mr. Despens discussed the possibility of a pause with the prosecutors?
I am not.
Now there came a time when you and Mr. Despens filed what's called a civil RICO complaint, right?
In the bankruptcy proceeding, yes.
And you sued a bunch of people, right?
Yes.
And that was all to seek a recovery for the estate, right?
Yes.
And as part of that, you would actually be able to recover triple damages, correct?
One of the claims would include a treble damage claim, yes.
And so if you won on that, that would bring in even more money into the estate, right?
Yes.
So even greater than the other adversary proceedings that you had filed, right?
Yes.
And again, that would be more money available to pay your firm's fees, right?
There would be more money in the estate to pay all fees and all creditors.
Okay. So that includes Mr. Despens's fees as well, right?
And all the other professionals in the case, yes.
Sure. Everybody is getting paid from that bankruptcy, right?
Yes.
Mr. Ferguson said, asked and answered.
The court said, "Sustained."
Now almost immediately after that civil RICO case was filed, Mr. Despens asked for it to be paused, right?
There was a motion filed in the bankruptcy case to pause or stay that action, yes.
Okay. And your firm filed that motion, correct?
Yes.
Okay. Did you review it before it was filed?
Yes.
Okay. And I take for granted that you know as a lawyer you have to be truthful to the court, right?
Yes.
Okay. Now one of the reasons that Mr. Despens told the bankruptcy court that he wanted to stay the RICO cases was to avoid interfering with the criminal prosecution. Correct?
Yes.
And in particular, he told the bankruptcy court that he wanted to avoid having to depose any of the witnesses that may be called by the government. Correct?
I don't recall that specific allegation in the motion. But I do recall the statement that he wanted to pause that RICO case because of this criminal proceeding.
Okay. Let me see if I can help you. Mr. Kumraju said, "Can we pull that up? Just for the witness and the parties, please. And let me know when it's on your screen, sir. Thank you. Okay. Could you just review this paragraph just to yourself, please? Okay. Does that refresh your recollection about one of the reasons being avoiding the possibility of deposing witnesses in the criminal case?
Yes. This refers to staying depositions in the main bankruptcy case. Not in connection with the RICO case, which was why I didn't recall that. But this is asking for staying depositions in the main bankruptcy case.
Mr. Kumraju said, okay. Could we go to paragraph 26? Okay. Just review that. Now if the RICO case was paused. Mr. Kumraju said, we can take that down. If the RICO case was paused, then there would be no depositions in that case either, correct?
Correct.
Okay. What's a deposition?
It's an out-of-court examination or questioning of a witness under oath.
And if there were a deposition in the RICO case? The trustees' counsel would have an opportunity to question them, right, the witness?
If it's a deposition noticed by the trustees' counsel, yes.
Okay. But even if Mr. Gua's counsel noticed the deposition, wouldn't trustees' counsel have an opportunity to ask questions?
Presumably.
Right. So if the trustee noticed the deposition, then Mr. Gua's counsel would have an opportunity. Correct?
Mr. Ferguson said, Your Honor, are we getting into hypotheticals? And it's also outside the scope.
The court said, I'll permit some exploration of this.
Mr. Kumraju said, I'm almost done, Your Honor.
The court said yes.
Let me make the question simple. In the event of a deposition, Mr. Gua's counsel may have an opportunity to question the witness, correct?
Yes.
And that would include witnesses that the government intended to call at this trial, if they were served with a deposition subpoena.
Mr. Ferguson said, Objection. Calls for speculation.
Mr. Kumraju said, I'd like to finish the question, please.
The court said, You're not finished?
Mr. Kumraju said, I have now finished.
The court said, It does call for speculation, so I'm going to sustain the objection.
Mr. Kumraju said, okay.
By Mr. Kumraju.
Until that stay is lifted, there will be no depositions in the RICO case, correct?
Correct.
And that's what Mr. Despens wanted, right?
Mr. Ferguson said, Objection.
The court said, Sustained.
That's what Mr. Despens told the bankruptcy court, correct?
Mr. Ferguson said, Objection. Asked and answered.
The court said, I don't know if that question was answered. You may answer.
It's what was included in the motion that we filed for Mr. Despens, yes.
And you're aware that's what the prosecutors want, right?
Mr. Ferguson said, Objection, Your Honor. He can't do that. And that misstates the testimony.
The court said, He can't know what the prosecutors want.
Mr. Kumraju said, No further questions, Your Honor.
Mr. Ferguson said, That's not what we want. That's fine.
The court said, Redirect.
Redirect examination. By Mr. Ferguson.
Mr. Skalka, you were just asked just a moment ago questions about the stay of the bankruptcy proceedings. The stay of the trustee's civil RICO case. Do you remember that?
Yes.
Are you aware that Mr. Kwok moved to stay the bankruptcy prior to the trustee making that motion?
Yes.
And he moved actually 2 times to stay the bankruptcy?
Yes.
And that's Mr. Kwok, correct?
Correct.
That wasn't the government that made that motion, correct?
Correct.
The court said, And what do you understand the meaning of moved?
The witness said, There was a motion filed.
The court said, What do you understand is a motion?
The witness said, It's a pleading, a document filed by a party to ask, in this case, to stay the Chapter 11 bankruptcy proceedings of the debtor.
The court said, Go ahead.
Mr. Ferguson said, Thank you, Your Honor.
By Mr. Ferguson.
Mr. Skalka, you were asked early on about the PAX lawsuit. Do you remember those questions on cross?
Yes.
And you were asked about whether, under Chinese law, there are death sentences. Do you remember that?
Yes.
What court was the PAX lawsuit filed in?
New York Supreme Court.
Is that in the United States?
Yes.
When Mr. Kwok was the subject of that lawsuit, was he in the United States?
Yes.
Does the New York court, where that lawsuit took place, apply New York law?
Yes.
Does it apply Chinese law?
Mr. Kumraju said, objection. Calls for a legal conclusion.
The court said, sustained.
Who is the judge?
In the PAX litigation.
In the PAX litigation?
The judge in the PAX litigation is Judge Ostrager.
To your knowledge, is he a member of the Chinese Communist Party?
Mr. Kumraju said, objection. Calls for speculation.
The court said, if he knows.
I don't know.
Does he apply New York law in his cases?
Yes.
Mr. Kumraju said, objection. Calls for a legal conclusion.
The court said, well, he may apply New York law and he may apply other law, depending on what is correct in the case.
Mr. Ferguson said, that's fair, Your Honor. That's fair, Your Honor.
By Mr. Ferguson.
You were also asked questions about the timing of the PAX lawsuit. Do you remember that?
Yes.
Mr. Ferguson said, Ms. Loftus, could we pull up Defense Exhibit 7006? Mr. Skalka, is this the complaint that started the PAX lawsuit?
It's the cover sheet for the complaint, yes.
Mr. Ferguson said, the government offers Defense Exhibit 7006.
Mr. Kumraju said, objection, hearsay.
The court said, the complaint is not already in evidence?
Mr. Ferguson said, no, Your Honor. It's a defense exhibit. The government is offering it.
The court said, sustained.
Mr. Ferguson said, all right. Ms. Loftus, can you show?
By Mr. Ferguson.
Mr. Skalka. Do you recall the exact details in the complaint about what happened before the date of the filing of this complaint?
Yes.
And what did PAX allege happened prior to their filing this complaint?
Mr. Kumraju said, objection. Hearsay.
The court said, sustained.
Mr. Ferguson said, Your Honor, I may need a sidebar then.
The court said, okay.
Continued on next page. At the sidebar.
Mr. Ferguson said, so yesterday, Mr. Kumraju objected to my asking this question. I said, is there going to be any cross on the fact, suggesting that PAX was acting as an agent of the Chinese Communist Party? Mr. Kumraju said he may ask the date. He asked the date and then he also asked, and you're aware that date was, the day before a red notice was filed by the Chinese Communist Party? Or are you aware that was the day before Miles Guo gave a Voice of America interview? So now there's a suggestion that this complaint, this entire lawsuit, was filed in conjunction with the red notice and with the Voice of America interview. That's not what the complaint itself even says. It talks about how they issued demand letters 2 years prior. They issued demand letters to Mr. Guo in 2015, they issued another demand letter in 2016, and then they filed. A year before this complaint, a proceeding in the BVI to put the entity, Shiny Times, that was the subject of the loan, into liquidation proceedings in the British Virgin Islands. If we're not allowed to elicit that fact, it completely distorts the picture of what this lawsuit was for the jury. And it will allow them to sum up in an incredibly misleading way its summations. And I understand that Mr. Kumraju was eliciting those things on cross to go to defendant's state of mind. Well, then the government can at least show what the complaint itself that Mr. Kwok read and supposedly had this state of mind that, oh, this must be a Communist Party plot. The government should be allowed to show what that complaint actually alleged happened before the date the complaint was filed.
The court said, how do you propose to elicit the testimony?
Mr. Ferguson said, I think the simplest way is just to offer the complaint and say it could be offered for its effect.
The court said, the whole thing?
Mr. Ferguson said, yeah, just offer it. It's 11 pages.
Mr. Kumraju said, there's no evidence in the record that Mr. Guo read the complaint.
Mr. Ferguson said, he filed an answer, Your Honor, and he testified that he filed an answer.
Mr. Kumraju said, so there's still no evidence that Mr. Guo read the complaint. The fact that the lawyers filed an answer is not evidence that Mr. Guo read the complaint, which is in English. By the way. Second. Everything Mr. Ferguson started with was they want to talk about the complaint for purposes of showing there was a demand letter and there was an action in BVI and there were these collection efforts. All of that is just for the truth.
Mr. Ferguson said, it's.
Mr. Kumraju said, so, excuse me. May I finish, please?
Mr. Ferguson said, I'm sorry.
Mr. Kumraju said, so if they're offering it for the truth, then obviously it's hearsay. If they're offering it for state of mind, they would have to have some evidence that Mr. Guo read it or saw it. Which is consistent with your Honor's prior ruling, and if they are offering it for some other purpose, then they need to establish it. But if they really want to get into Pax's motivations for filing it, then call a PX witness. But putting in a hearsay document because they have concerns about the way we're going to sum up is not the way the evidence works.
Mr. Ferguson said, we have no objection to Your Honor instructing the jury that this document is not coming in only for its effects.
Mr. Kumraju said, you still don't have evidence he read it.
Mr. Ferguson said, this wasn't a third-party litigation. Mr. Guo was the defendant. This litigation was going on for years. He was threatened to be put in jail. He filed an answer. He was deposed. He was also served with the complaint.
The court said, all right. I'm going to allow that.
Continued on next page. In open court.
Mr. Ferguson said, the government offers Defense Exhibit 7006.
The court said, so the objection is overruled and the document is admitted.
Defendant's Exhibit 7006 received in evidence.
Mr. Kumraju said, with a limiting instruction, Your Honor.
The court said yes. The complaint is not being offered for the truth of the statements contained in the complaint, only for its effect upon the reader.
Mr. Ferguson said, thank you, Your Honor. Ms. Loftus, if we could scroll down.
By Mr. Ferguson.
Now, Mr. Skalka, could you read paragraph 1, please?
This is a straightforward breach of contract case. Kwok Ho Wan.
And you can skip the A/K/S.
A reported billionaire. And his controlled entities borrowed millions of dollars from Plaintiff Pacific Alliance Asia Opportunity Fund LP. Pax LP, but have failed to pay any of the amount owed to Pax LP under binding written agreements.
Mr. Ferguson said, and if we could zoom out, Ms. Loftus. Let's scroll down, please. Scroll down. Keep scrolling down. And keep scrolling down, Ms. Loftus. Keep going, please. You can go more quickly. Yeah, keep going. All right. I'm sorry. Scroll back up, please. Sorry. One more.
By Mr. Ferguson.
Okay. Now towards the bottom, Mr. Skalka. Do you see the bold that says Pax LP seeks to enforce its contractual rights and collect amounts owed?
I see that.
All right. Can you read paragraph 38, please?
On October 16, 2015. After the deeds of settlement and option agreement were terminated and the 2011 facility letter reverted to being in full force and effect, Pax LP sent a written notice of demand, the notice of demand, to Kwok's address in Hong Kong, as specified under the terms of the personal guarantee.
Generally speaking, what's a notice of demand?
In this case, written notice of demand is a letter demanding a full payment, or payment on an obligation or a debt.
And this was alleged to be sent in 2015, right?
That's what the allegation is, yes.
And is that around a year and a half before the ultimate filing of this lawsuit in April 2017?
Yes. Down.
Mr. Ferguson said, let's zoom out, please. Let's scroll next page. Can you read paragraph 40?
Kwok never responded to the notice of demand.
Can you read paragraph 41, please?
On February 19, 2016, Pax LP sent a letter to Shiny Times demanding payment of $82,219,404.08 due and owing under the 2011 facility letter, the Shiny Times demand letter, which represented the principal plus contractual interest of 15% per annum calculated up to the date of the Shiny Times demand letter.
And February 2016, is that over a year before the ultimate filing of this lawsuit in New York court?
Yes.
Mr. Ferguson said, "Can we zoom out, please?" Now can you read the first sentence of paragraph 43, please?
When Shiny Times did not respond, Pax LP submitted an application to court in the British Virgin Islands, BVI, on February 29, 2016. Seeking the appointment of joint liquidators to put Shiny Times, which is a BVI corporation, into liquidation. The application alleged that,
And that's good, Mr. Skalka. Is that also over a year before this New York State court action was filed?
It's about a year.
Mr. Ferguson said, "All right. We can take that down." You were asked questions about whether, withdrawn. Mr. Ferguson said, "If we could pull up, Ms. Loftus, Government Exhibit 1407 and go to page 7. And if we could zoom on the bottom portion, part 7. Mr. Skalka, do you see the first sentence says, 'I have examined this petition, and I declare under penalty of perjury that the information provided is true and correct?'
Yes.
Is there any exception in this document for being targeted by the CCP?
No.
If you're targeted by the CCP, do the perjury laws not apply?"
Mr. Kumraju said, "Objection. Calls for a legal conclusion."
The court said, sustained.
Does this document say that the perjury laws do not apply if you're targeted by the CCP?
Mr. Kumraju said, "Document speaks for itself."
The court said, sustained.
Now, Mr. Skalka. You were also asked questions about the summary judgment ruling entered by Justice Ostrager?
Yes.
And you were asked questions about how G clubs didn't pay that fine, correct?
Correct.
Or, I'm sorry, that judgment. And you were also asked the same about the contempt fines, right?
Yes.
You were asked how G clubs didn't pay that and the Himalaya Exchange didn't pay that, correct?
Yes.
Who lent the money for the $37 million loan that kept the PAX litigation stayed? What was the entity?
Himalaya International Finance or Financial Group.
Are you aware that that entity is connected to Himalaya Exchange?
I believe there is a connection.
By the way, do you know why Migwa needed a loan to pay that money?
Migwa's attorneys had alleged in the bankruptcy proceeding that the only asset of HKUSA was the Lady May.
And do you know why Migwa didn't give HKUSA the money herself and instead got a loan?
I do not.
Mr. Kumraju said, "Objection. Calls for speculation."
The court said, sustained.
Mr. Ferguson said, "I'm just asking if he knows." He doesn't know. Do you know why the initial loan agreement said ACA Capital?
Mr. Kumraju said, "Same objection."
I don't.
The court said, sustained.
Do you know why it was changed to Himalaya International Financial Group?
Mr. Kumraju said, "Same objection."
The court said, sustained.
You were also asked what happened ultimately to that $37 million. Why did the bankruptcy judge find it was part of the bankruptcy estate?
The judge made a finding that HKUSA was an alter ego of the debtor and therefore made a finding that the Lady May was property of Mr. Kwok's bankruptcy estate and the funds in escrow were property of Mr. Kwok's bankruptcy estate.
You were asked several questions about the Office of the U.S. Trustee, Department of Justice.
The court said, one moment. It's time for our break.
Mr. Ferguson said, "Oh."
The court said, so members of the jury, don't discuss the case amongst yourselves. Don't permit others to discuss it in your presence. Don't read or watch or listen to anything from any source that touches upon the subject matter of this case. Sir, you can step out. Don't discuss your testimony.
Jury not present. Witness not present.
The court said you may be seated, and we'll have a sidebar.
Page 4162 sealed by order of the court. Afternoon session 12 p.m.
The court said, please have the jurors brought in.
The law clerk said, "Jury entering."
Jury present.
The court said, please be seated. Remember, sir, that you're still under oath, and you may continue the redirect.
Mr. Ferguson said, thank you.
By Mr. Ferguson.
Mr. Skalka. You were also asked questions on cross about the office of the U.S. Trustee in bankruptcy proceeding?
Yes.
Is that also the same or a different office from my office?
It is different. Their role is to oversee the administration of bankruptcy in every federal district in the country.
You also were asked on cross about how targeting by the CCP and issues related to that made this bankruptcy unique. You remember those questions?
Yes.
And you said I guess that could be one factor about what made it unique. What were some of the other factors that made this bankruptcy unique?
The fact that the debtor indicated that he had virtually no assets on his bankruptcy schedule, but listed over $373 million of liability. It was unusual to me in my experience as a bankruptcy attorney. As I noted, I believe earlier, the fact that there were protests associated with the bankruptcy case was unique. To be frank, most bankruptcy cases are fairly dry. They're disputes over money. So it's not uncommon to see a lot of debts and disputes over how those debts are going to be paid. But usually you don't see protests and bankruptcy courts getting involved with providing restraining orders and First Amendment right claim in a bankruptcy proceeding. That's unusual.
Mr. Ferguson said, no further questions.
The court said recross.
Mr. Kumraju said, thank you, Your Honor, just briefly.
Recross examination. By Mr. Kumraju.
Can we have DX 7006, please? This is a complaint, right, sir?
Yes.
The complaint filed by PAX?
Yes.
So PAX decides what to put in here, right?
It's my understanding.
And these are PAX's allegations, right?
Correct.
And you have no way of knowing if any of what's in here is true, right?
I know their allegations, and I know what the court found. That's my knowledge.
An allegation is just an allegation, right?
Yes.
And Mr. Gua denied the allegation, right?
Correct.
And this complaint was filed online, correct?
It was filed with the New York County Clerk electronically, but online. Not necessarily on the internet. What do you mean by online, I guess?
Not to get too inside baseball. When you file something electronically, you go on the internet and file it, right?
Yes.
Can we pull up DX STIP 0001, please? Can we go down? You see paragraph 5 there?
Yes.
Could you read the first sentence?
To carry out some of the objectives of Fox Hunt in 2017, the PRC government tasked a specially designated group of operatives. The group, with discrediting and harassing individuals, including Mr. Guo, by using interactive computer services and electronic communication systems.
We can pull that down. 2017, that was the year that the PX litigation started, right?
Yes.
Can we go to the next paragraph? Can you read the second sentence, please?
In May 2017, the PRC government sent 4 undeclared agents from the PRC Ministry of State Security, MSS, to the United States to attempt to cause Mr. Guo's coerced repatriation to the PRC as part of a Fox Hunt initiative.
May 2017, that's the month after PX filed its litigation, right?
I think it was a couple months after. I believe it was filed in February of 2017.
Mr. Kumraju said, no further questions.
Mr. Ferguson said, just one question.
Redirect examination. By Mr. Ferguson.
Mr. Skalka, are you a Chinese spy?
No.
Mr. Kumraju said, one last one.
Recross examination. By Mr. Kumraju.
If you were a Chinese spy, would you tell us?
Mr. Ferguson said, calls for speculation, Your Honor.
The court said, you may step out, and the government may call its next witness.
Witness excused.